Towards the end of July, the MEIBC Management Committee made a decision to approach the Minister of Labour to extend their agreement between CIFSA mainly and NUMSA on the other side and a couple of trade unions to extend that agreement to non-parties. NEASA felt that that decision was irregular on many grounds, and we thought that the decision to ask the Minister and the contents of that agreement was irregular and unlawful on many grounds. We therefore filed a urgent application in the Labour Court and requesting the judge to grant an award in our favour that forbid, firstly, the MEIBC to extend the agreement, and the Minister to, if he receives such an agreement, to extend that agreement to non-parties. The judge didn't agree with us. He found against us in all respects. And we filed a leave to appeal before the same judge, and he turned down that request. So our opposition is so happy about this thing, and I think we thought it fit to brief you this morning on exactly what this matter is all about, and to put your mind at rest about the fact that we are dealing with this matter the best we can, and I think that eventually we will be successful. Jaco, just take us through a very important element of the judgment, especially the fact that in this judgment the judge dealt with both the urgent application as well as the review. Just explain this very briefly.
All right, thank you. So, as you mentioned, we brought an application to interdict the council, first of all, to request the minister to extend that agreement. And secondly, if they had already done so, already sent the request by the time that we were in front of court, to then interdict the minister from extending that agreement pending the finalisation of a review application. So it was a two-part application. The first part was an application for an interim interdict, and the second part was the review application. So the idea was for the interdict to operate while the review application is pending. So it's interim. But what happened is that the judge decided, well, I'm hearing this, I'm dismissing the part A, the interdict, and I'm also dismissing part B, the review, which was never before him in the first place. So he couldn't dismiss a matter.
Matter was never argued.
Never argued before him. Secondly, in respect of that, the judge, in our view, applied the wrong test. He said we did not make out a case for relief, for interim relief, but he applied the test for final relief in our application for interim relief. It's two very different tests. So our view is he completely erred by applying the incorrect test, and that therefore is wrong, and that should be appealable. What's also interesting in respect of the application for leave to appeal is that there are conflicting judgments in respect of the interaction between the council's constitution and the LRA. And that on its own should be sufficient for leave to appeal to succeed to the LRA, to the LAC, I beg your pardon, because we need clarity on that matter. The Labour Appeal Court needs to be clarity in respect of the interaction between these two pieces of legislation. But the judge is of the view that there is no contradictory judgment, and therefore also dismissed our leave to appeal request.